Welcome to literary and jury charge practice. Let's start out with a little warm-up. This literary is about the Miranda Decision. Ready? Here we go. The Miranda Decision set forth that all individuals must be told what these two rights are to help them get a fair trial. It is not a few people who already know what their rights are who are protected. All people must be informed of their rights. Accordingly, this decision was important because it ensures that people who get the protection that was given to them under the Constitution of the United States. When the Miranda Decision was handed down, it was designed to help even those people who were not aware of the rights granted them under the Constitution. The Miranda Decision is an important decision that was handed down. The fact that someone is Mirandized or informed of their rights to an attorney and their right to remain silent is important for several reasons. If the person is not Mirandized properly, the state immediately loses. Someone who deserves to go to jail may be set free. On the other hand, the poor, who deserve the same information as others, are given the right to have this information. Everyone must be Mirandized. The steps in a criminal case differ considerably from the steps in a civil case. In a civil case, a plaintiff usually hires an attorney to file a complaint with a court. The complaint lists the damages and how the plaintiff expects to be redressed for the wrongs done to him. The defendant files a response after receiving the complaint. From that point, the case progresses toward trial. Once it is determined that a court date is set, both parties seek to obtain all the evidence that they can to support their sides. A hearing is often set up to determine if there is enough evidence for the case to proceed. If there is enough evidence, the case then goes to trial or it is settled. In a criminal case, first, the defendant must be charged with a crime. To be charged with a crime is a substantial process. First, either a grand jury must be convened or the district attorney's office must charge the defendant with a crime. If a grand jury is convened, the grand jury is given evidence to review to see if enough facts point to the defendants having committed the crime. If, after the grand jury meets, it decides that the defendant should be charged, the defendant is so charged with a crime. Another way for the defendant to be charged with a crime is being charged by the district attorney's office. The difference is that when a party is charged by the grand jury, the charge is called an indictment. When the party is charged by the district attorney's office, it is called an information. A person charged with a crime is entitled to be released on bail pending trial. Bail is security given for the release of a jailed person, which then ensures the defendant's attendance at all required court appearances. Right. Sorry. Let's get back to this article we started called Ruminations on Reporting. Ready? Here we go. I am proud to have known or grown up with some of the great men and women of your profession. My dad and granddad, Vince Varallo Jr. and Sr., my cousin Ed Varallo, Ann White, the late Jean Maurer, Jack White, Henry Skogmo, Harry Foster, and many others. Some were regulars at family parties and events. Others were guests at professional events. In short, maybe it is in my blood. So enough about my perspective. The question that I set out to answer is this: what is going on in your profession, and will there be a profession here having meetings like this one 15 or 20 years from now? In thinking about that topic, I spent some time thinking specifically about technology and its intersection with the profession, technology in the courtroom, and technology in the deposition suite. I got to thinking about things like courts doing away with live court reporters, like our bankruptcy court did a few years ago, and spent some time ruminating on one of my favorite recent reads, Tom Friedman's The World is Flat, for its powerful observations about how we are no longer competing with each other, but with transcription centers in Bangalore and Trinidad, and with entrepreneurs in Shenzhen and Mumbai. As I thought about some of these currents which have run through global commerce like tsunamis sweeping in from the ocean, and how the tiny court reporting world has been rocked by one incursion after another against the previously secure positions held by those who have set themselves to the highest standards of competence and professionalism, like this group, it occurred to me that there is very little that is really new under the sun. In point of fact, the debate about the incursion of technology into the profession has been going on for quite some time. I recall when, as a young man, some 30 years ago, the local profession was rocked when the Delaware County courts in Pennsylvania installed electronic recording devices and phased out live reporters. I likewise recall the first use of computer-aided transcription, the introduction of innovations like LiveNote and other real-time transcription software, and the appearance of litigation support as an offering made by reporters and their firms rather than purely by technologists. But more importantly, I also recall the reaction of some in the profession to each. All right, we will get back to that article and hear the rest of what that attorney has to say. But again, that is an older article. It was from 2008, so keep that in the back of your mind when you're listening to some of the things maybe that he's saying. All right, let's get back to some jury charge practice. Ready? Here we go. The court reporter is making a record of everything that is said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. You alone must judge the credibility or the believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. All right, let's get back to the Ruminations on Reporting by this attorney who grew up in a court reporting family. Here we go. Ready? It is my contention that in almost every one of these cases, those who embraced relevant advances in technology to deliver their services faster and more effectively not only survived, but in some cases did better than before. Correspondingly, I believe that those who failed to embrace relevant technology suffered and in some cases lost altogether. Allow me, if I may, to illustrate the point with a few concrete examples. Let's start with the first incursion of technology into the court reporting world, the introduction of machine shorthand in the courts. I actually know a little something about this because it was my grandfather, Vincent Varallo Sr., who in 1937 was hired by the president judge of the Philadelphia Common Pleas Court as the first machine shorthand reporter in the Philadelphia court system. In order to prove that it worked, my granddad was assigned not one, but two judges and reported the proceedings of both for a full year to prove that the predecessor of the shorthand machine that you all use every day was actually more useful than taking steno notes by hand. Think about how that technology was received in a profession of almost exclusively pen writers. Some, of course, thought that if they ignored it long enough, it would go away. Others were curious as to whether it made their professional life easier or helped them produce better quality work. Guess who survived? Let's just say that there don't appear to be too many pen writers around, and just about everyone I've run into in my 25 years of litigating has had a shorthand machine with them in depositions and court. Fast forward to the 1970s when this thing called computer-aided transcription was first introduced. Some of you may be old enough to recall the mini computers that were first used to interpret the key strokes made with an enhanced shorthand machine. In this case, early adopters had a great sales tool. They could tell attorneys that they were with it, and best of all, could begin to deliver key word lists with transcripts that allowed attorneys to perform quick searches. Even better, court reporters who made the switch to a CAT platform could deliver their transcripts on a floppy disk, meeting the early demand of the best litigators for a transcript that could be fed into litigation support software. Right, we will get back to that article. He's actually giving a good history of machine shorthand. All right, let's get back to our jury charge practice. Ready? Here we go. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If during the trial you have a question that you believe should be asked of a witness, you may write out the question and send it to me through the bailiff. I will discuss the question with the attorneys and decide whether it may be asked. Do not feel slighted or disappointed if your question is not asked. Your question might not be asked for a variety of reasons, including the reason the question may call for an answer that is inadmissible for legal reasons. Also, do not guess what the reason was your question was not asked, or speculate about what the answer may have been. Always remember that you are not advocates for one side or the other. You are the impartial judges of the facts. Let me explain something that this jury instruction does not mention. It's a fairly new instruction, but I'll just mention this. I'm not going to call a witness back to answer a question for the jury. So if you're a juror and you hear something that you think should be asked of that witness, usually wait. It probably will be asked. And that will conclude our literary and jury charge practice.